Your Honor, we're back and I think we're ready, but I see that we're still missing Miss Acosta.
That we are.
And both Miss Fuller and I have reached out to her and neither have received a response.
Okay. Did anybody have any idea of what her position was prior to today, or anybody talk to her about this case?
I think she just recently got appointed, maybe even just as late as yesterday. So, because Miss Collins was the original ad litem, and then she had a conflict. So
Right,
she,
but I think that was done last week. Um, Let me see.
oh yeah, could have been.
Yeah, I was the one that did the appointments, and then I changed it to Miss Acosta. I'm pretty sure it was last Wednesday, I think, is when that was. So I just didn't know if anybody had had a chance to talk to her. Um, Let me see if I can reach her. Maybe if my name pops up, she'll answer. Give me a minute.
I'm sure you have more pull than us.
I received her voicemail, so I'm assuming she's probably involved in a proceeding somewhere else. And I'm also assuming that because this was just last week where the substitution was made, she may not have received notice. Is there any objection from any of the attorneys or in the department to moving forward without her?
I mean, I think it would be important for her opinion, but
And I don't know. I think we have an agreement with the parties that are here, but I don't know in terms of her client.
Well, her clients are two and not one yet. So I know she's not going to be able to confer with them,
Okay.
but I don't know if she's had a chance to check in and look at the situation. But um, I think we could give it probably a few more minutes and then figure out what we want to do from there. So it's 10:48. Let's give it 5 more minutes and then I'll check back in with everybody. Received anything back from Miss Acosta? Have either one of you heard anything from her?
no, Your Honor.
No, sir.
Well, how do the parties wish to proceed?
I guess we can go forward.
I'm okay with that.
We're going forward, Mr.
Yes, sir.
Weatherby?
That'd be fine, Your Honor.
Okay.
Good.
With Ms. Kyler Green, would you please begin the announcements?
Yes, good morning. Emily Kyler Green, attorney for the department.
Ashley Peterman, investigator for Child Protective Services.
Taylor Gonzalez, family-based caseworker.
Deborah Fuller, attorney for the mother, Brittany Hernandez. Miss Hernandez, could you unmute and announce?
I'm Brittany Hernandez. I'm the mother
Thank you.
my.
Charles Weatherby, attorney for the father. Mr. Lawfey, would you announce your presence, please?
Marcus Laffey, and I am the father.
Okay, we're here for a court order services case. My understanding is the parties have an agreement.
Yes, Your Honor.
All right, you want to lay out?
It is a partial agreement, Your Honor. So
Okay, so let's hear what's agreed. Is the non-agreed part, is it going to be, is it a big contested issue or is it something we can wade through without Ms. Acosta here?
I think we can do it without her.
Okay. And just since I wasn't on the record when we talked about it, Ms. Acosta was substituted in for Ms. Collins on this case last week. Don't know if she received notice of the appointment. I gave 20 minutes, over 20 minutes for her to log in, and she's not here yet. The parties have agreed to move forward without her, correct? Is there any objection to that?
No
No
objection.
objection.
Right. And for the record, she does represent the children who are 2 years of age, and the other one is not quite a year yet. So these are very, very small children. Okay, let's hear the agreed terms and conditions, Ms. Kyler Green.
Thank you, Your Honor. The department is requesting a TFF program through the Parents as Teachers program. For the parents to engage in that. The specific services for the mom include a psychological evaluation, individual counseling, couples counseling with the father, And for the father, individual counseling, couples counseling with the mother, and both of those are under the Parents as Teachers program. That's it from the department's perspective. I'll let Ms. Fuller discuss what is not agreed upon.
You're not asking the father to do a psychoval?
To my knowledge, no. If Ms. McKetta or Ms. Gonzalez, if if what I received is incorrect, you guys can speak to that. But that's what that's my understanding.
Okay, Ms. Fuller.
And my issue is the fact that it's a TFF case, Your Honor. These parents, my client specifically, requested to do services, agreed to do services over 6 weeks ago. And I don't think that she needs to be court ordered to do these services. She wanted help, and she hasn't gotten it, to this date. And I don't think the court needs to be involved to order her to do it. She wants the help. And so I don't like the fact that there's going to be a finding of abuse or neglect on a case that was just chosen to be a TFF case because of whatever the legislature is doing with that. And I feel like that this family will do the services through family-based safety services like they agreed to 6 weeks ago. And I really do not feel that it should be a TFF case. So that's my issue. I don't want a finding of abuse or neglect because I don't think the affidavit provides the information to show that that is the case. And it is my understanding that the allegations are being ruled out. And so I would ask that it be a family-based safety services case and that these parents be able to get the services they need and that it not be a TFF case.
Well, it sounds to me as if you're asking the court to dismiss court intervention completely.
I don't think there needs to be court intervention.
So then we don't have an agreement. Mr. Weatherby?
My client is agreeable. I think the reason that the parents as teachers is not available to family-based services that I'm aware of.
Well, I'm not so we've got two problems here. One is I'm not hearing that we actually have an agreement, and number two, we don't have Ms. Acosta here to have a contested hearing.
Well, Your Honor, I think that we have an agreement as to the services that the parents will do. And what we're talking about here is a logistical issue of whether it's under the umbrella of TFF or whether it's under the umbrella of family base. And this case was, I don't know, requested and approved for TFF, thus the need for a court order for that. I understand the problem with what we're calling it, but we have an agreement as to the services, which include parents as teachers, which necessitate a court order.
Okay.
My understanding is that you can do the parents as teachers without court intervention, and so I don't know that it's necessary. I have a problem with a program picking a case when I don't feel that it's necessary to have a court involved. I don't know. I mean, I don't know how that works. I don't know exactly how they do that, but this is a family that wants services. That's what family-based is about. Okay. And you don't have to go to court.
Family-based does not involve court intervention, but we're here on a TFF case for court-ordered services, so we don't have an agreement for court-ordered services. We don't. We've got a situation where Mr. Weatherby's client and the department are in agreement, but Ms. Fuller is not, and so without Ms. Acosta here, I can't move forward unless we're agreed for court-ordered intervention, because that's what Hang on, sir. We're handling procedure here.
Well, and my client's in agreement with the services. That's not the issue. They wanted the services. They've asked, they've been in agreement with the services. It's just I don't feel like the court has to be involved with it. That's
again, I get that. I understand that, but we're here for the court to order these services, and so there's no agreement. So we're going to have a contested hearing. So I'm going to have to reset it because I need Ms. Acosta here. We can't move forward. So I'm looking at next week. We'll do it Thursday the 1st. Get with Miss Greenlee on a time, please. I don't know what we have set right now on Thursday the 1st. I know this is a Bandera case, but I'm going to put everything on Thursday next week if I can. My first case is at 10. we had a case that was going to be set for 9. I think we can do this one at 9:30. If it's going to be contested, how long are you going to need? I mean, it's court order services, so I'm not going to give it any longer than an hour. That's it.
Okay.
Let's set it at 9 next Thursday. If somebody could please make sure Miss Acosta knows. I'll send Miss Greenlee an email right now with the same information, but between all of us, I want to make sure she gets that notice that we're resetting to February the 1st at 9 a.m.
We'll send a reset order to the court, Your Honor.
Okay, and do try to talk about this a little bit before we go back next week if you can. But I want to make it very clear, if you don't have an agreement for court order services in this case, unless there's going to be a non-suit, we're going to have a contested hearing at 9 a.m. next week. That's the only option we have. Okay, so I'll see you all back February 1st, 2024 at 9 a.m. Thank you all for your time and your service. All parties are excused.
Thank you.
Well, we don't have anyone here for the MTI, so
that does not surprise me.
I'll call it and you can get a recording and put this stuff on the record. In the 454th Judicial District Court of Medina County, Texas. This is for a motion to investigate, which the law now requires notice to the parties, and it may not be ex parte, and I'm recording this, zooming outside of Medina County due to my illness. And we will move forward with testimony now. Ms. Rosales, you have filed a motion to investigate with an affidavit stating the reasons why you need the motion to investigate. Are all of the facts and circumstances and allegations in your affidavit at this time true and correct as of today?
Yes.
All right. Briefly sum up for me, for the record, why you need the court to order the ability for you to investigate this case at this time.
We received this intake back after Christmas. Since then, we've made attempts to make contact with the parents to allow them to see the children, and they've avoided us in all of our efforts due to the children's young age, being vulnerable, not able to seek help if needed in the home, and concerns for possible domestic violence in the home, or seeking intervention to be able to see and interview the children at this time.
To your knowledge, were all 3 of the parents who were subject of this motion to investigate, Ashley Hernandez, John Anthony Del Toro, and Santiago Hernandez, have they been served with notice of this hearing?
Yes.
So they're aware that the court was going to hear your testimony this morning as to the motion to investigate?
Yes.
All right. And the court will take notice that there are no other parties here at this time for the motion to investigate, and I do not have any of the parents in the waiting room. You believe that this order is necessary for you to fully investigate the concerns of abuse or neglect in this case?
Yes.
And you've made all efforts to try to get this information prior to reaching out to the court for an order?
Yes.
You're asking the court to allow you to enter the home and or any place where the children may be located to interview them in full?
Yes.
And you're asking the court to order the parents to allow you to conduct this investigation, interview, and examine the children without interference?
Yes.
As well as any other members of the home?
Yes.
All right. You believe that would be in the best interest of the children?
I do.
All right. It's granted. Ms. Kyler Green, if you get me an order, we'll get it signed for you today.
Yes, Your Honor. Thank you.
If you can get it over. Okay. Thank you, Ms. Rosales.
And Your Honor, we do have an agreement. And if I could lay it out, since I just cleared everything with my client, and then Ms. Kyler Green can add anything that she wishes.
I'm okay with that, Your Honor.
Is that okay?
Yeah, let me get the case called and get everybody sworn.
Sounds good. Thank you, Judge.
Then Ms. Kyler Green, please begin the announcements. And if I cough, I apologize.
Emily Kyler Green, attorney for the department. Ms. Turner.
Stacy Turner, investigator for the department.
Cecilia Howring on behalf of the mother.
Richard Saldivar, attorney for the father, Mr. Quintero. Mr. Quintero, will you unmute and announce, please?
Can you hear me?
We can hear you. State your name, please. You muted when you stated your name.
Oh, Alfred Quintero, Your Honor.
Thank you. Miss.
Your Honor, Christine, are you able to unmute, or if so, please announce. If not, then there you go. Could you please?
Yes, I'm here. Christine Quintero.
Thank you.
Yes, ma'am.
Jennifer Harris, I've been appointed to represent the alleged father, Mr. Gonzalez. I'm announcing not ready, Your Honor. He has not been served, and I have not had contact, and it's my understanding that no one with the department's had contact.
Kathleen Savage, attorney ad litem for the child, Your Honor. I'm ready.
Marcus McMore, Hill Country Casa.
Matt Jenkins, Hill Country Casa.
Ms. Harris is announced not ready. Her client has not been served. I'm inclined to grant the not ready as to Mr. Well, I've got it backwards in here. So in my system, it says that Mr. Saldivar represents Mr. Gonzalez, but he represents Mr. Quintero, correct?
That's what I have, Judge. I don't. Maybe, did I read that wrong? I thought it was Mr.
That's how I was doing it as well, Your Honor.
Okay, it's just the names are backwards here in the system. We just need to fix that. Okay, so I'm going to grant that not ready on behalf of Miss Harris and Mr. Gonzalez. Miss Kyler Green, to the parties. Excuse me, Miss Hellrung said the parties have an agreement. Any objection to Miss Hellrung letting out the agreement?
I have no objection.
No, Your Honor.
Go ahead, Miss Hellrung.
Thank you, Your Honor. The agreement with Ms. Quintero is that she is agreeing to temporary managing conservatorship of the department. In doing so, she is acknowledging that the evidence would be sufficient to move forward. However, she is not agreeing to the facts as laid out in the affidavit. She is agreeing to work services to be developed at the family group conference, which is currently scheduled for February 23rd in person. Finally, she is agreeing to have in-person visits with her child once a month for 4 hours due to transportation issues. The child is currently placed with her mother, the child's presumed aunt, and my sister, or my client's sister-in-law. We are asking, I believe, for the court to ask for an expedited home study on the caregiver. The child was just placed, I think, a couple of days ago. Finally, she is asking for weekly virtual visits with the child for 1 hour.
And what about the other parties?
As far as Mr. Quintero, I believe there is an issue as to paternity. They are legally married, so he is the presumed father. But both Mr. and Mrs. and Mr. Quintero and my client acknowledge that he is not the biological father. So he is asking for DNA testing and requesting that the court order DNA.
Okay, what about the rest of the agreement?
Your Honor, the only issue the department has is we don't object to the virtual visits, but 1 hour for the child of this age is just too long. So we would request that the court just say, I don't know, for I don't know, 15 minutes for as long as the child can have any sort of attention span for the virtual call.
I think she'd be okay with up to 1 hour if it's appropriate, but obviously given the age of the child, that actually makes sense.
And additionally, Your Honor, the department requests for the court to take judicial notice of the reasonable efforts made by the department in the affidavit, and also to take judicial notice of the appearance of the parents who are here today.
Let me back up a step. I understand Mr. Quintero is contesting paternity at this time, pending the DNA, but at this time he is listed as the presumed father due to the marriage. So until that DNA says otherwise, does he agree to the rest of the terms of the agreement?
Judge, I believe so. I mean, if we can get Mr. Quintero to unmute.
Mr. Quintero, did you hear the terms and conditions of the agreement?
Yes, I agree.
Okay. Did you enter into this agreement voluntarily?
Yes.
Were you forced to enter into the agreement in any way?
No.
You understand the agreement?
Yes, I do.
You're asking the court to adopt and approve the agreement today?
Yes.
Okay, thank you, sir.
Thank you, Your Honor.
Ms. Quintero, can you unmute, please?
Oh.
Did you hear the terms and conditions of the agreement?
Yes, sir.
And this is your agreement that you made?
Yes, I agree to everything.
You had the opportunity to discuss it with your attorney?
Yes, sir.
You weren't forced in any way to agree to this or made any promises to get you to agree to it?
No, I was not.
Okay, you're asking the court to adopt and approve this agreement?
What's that?
You're asking the court to approve the agreement? Okay. Now let's look into the issue of the visitation. This is a 1-year-old child, so I mean, an hour for virtual is really long. So I think what we need to be looking at is probably more realistically 15 to 20 minutes. So I want to make sure that the order says virtual visits for up to 1 hour max, subject to child's behavior. So if the child is crying or upset or running around and it just doesn't work out very well, things aren't jiving, then we need to cut it off. But I wanted to make sure she gets a minimum of 15 minutes. I think that's fair on those virtual visits. All right, and then I'll order the DNA testing. Anything else that you want to add on behalf of the children, Ms. Savage?
No, Your Honor. The child was placed with Mr. Quintero's sister. That placement seems to be meeting his needs at this time. And so I just asked that we try to expedite that home study to try to get her any additional assistance.
Okay. And you're good with all the other terms of the agreement?
Yes, Your Honor.
All right. Excuse me, I'm sorry. Mr. Jenkins, this is the agreement that CASA made?
Mr. Jenkins is new to the case. Yes, sir. This is the agreement we made.
Okay. All right. So, Mr. McLemore, you believe this agreement's in the best interest of the children?
Yes, sir. We do.
All right. Ms. Turner, you're the investigator?
Yes, sir.
All right. You believe that everything that was in your affidavit at this time, date and time is true and correct?
Yes, sir.
All right. Now, Ms. Hellrung, I understand that your client is not going to agree to the allegations in the affidavit. And I'll make a note of that on the record. But Ms. Turner, you believe that I know the mom doesn't, but you believe there was a danger to the physical health or safety of the child?
Yes, sir.
You believe that was caused by an act or failure to act of a person entitled to possession and for the child to remain in the home is contrary to the welfare of the child?
Yes, sir.
You believe that all reasonable efforts to avoid the removal were made and to allow the child to return home?
Yes, sir.
And that was consistent with the circumstances and providing for the safety of the child?
Yes, sir.
You believe that if the child had been returned home, there had been a substantial risk of continuing danger?
Yes, sir.
You believe that the agreement that's been made by the parties today is in the best interest of the child?
Yes, sir.
Okay. All right, then. The court will find, pursuant to Chapter 262 of the Texas Family Code, that there's sufficient evidence to satisfy a person of ordinary prudence and caution that there was a danger of the physical health or safety of the child caused by an act or failure to act with the person entitled to possession for the child to remain in the home is contrary to the welfare of the child. The urgent need for protection required the immediate removal of the child, and reasonable efforts consistent with the circumstances of providing for the safety of the child were made to eliminate or prevent the child's removal, and reasonable efforts have been made to enable the child to return home, but there's a substantial risk of a continuing danger if the child is returned home. Court will also add in as part of the agreement under Chapter 262.013 that the mother in this case does not admit to any of the allegations in the affidavit by nature of her agreement. Court finds that the agreement of the parties is in the best interest of the child. Court finds that this agreement does not include Mr. Gonzalez, who has not been served yet and is not party to the suit at this time. Court finds that it's in the best interest of the child for the Department of Family Protective Services and belong to be named as the temporary managing conservator, for the parents to be named possessory conservators, and for the parties to attend a family group conference on February 23rd, 2024. Visitation with the mother at this time will be in person once a month for 4 hours, and then virtual visitation for up to 1 hour maximum, subject to the child's behavior, but a minimum of 15 minutes weekly. Court will also find that Mr. Quintero contests paternity, although he is a presumed father, and will order a paternity test to take place as soon as possible. Did y'all talk about Mr. Quintero's visitation, considering he's the presumed father and he's contesting paternity?
It has not been discussed, Your Honor, but it's from the department's perspective that he not have any visitation at this time.
Is there any objection to that, Mr. Salazar?
Judge, I believe that Mr. Quintero has seen this child and been around this child before. The child's familiar with him. I don't see the harm in having supervised visitation if the child's familiar with him. If Mr. Quintero wants that.
I think the issue that the department has is that if he's contesting paternity, they're not going to want him around the child.
That's exactly right, Your Honor.
I understand, Judge.
Okay. So I think that's fair. I understand he might have a relationship with the child, but considering he's claiming to not be the father, I'm not going to order any visitation with Mr. Quintero at this time until we get a DNA test back that says otherwise. Court will take judicial notice of the reasonable efforts made. Actually, excuse me. Is there any objection to any of the, or do the parties stipulate to the reasonable efforts in the affidavit?
Yes, Your Honor.
Okay. So the court finds the parties do stipulate to the reasonable efforts made by the department in the affidavit. Court will also find that Mr. Quintero and Ms. Quintero both appeared today and entered into an agreement, and thus the department is relieved of any further obligation to serve them with citation and notice as they've entered a general appearance. Court will find that the placement of the child with the aunt of the presumed, or the child's, I guess it's the sister of Mr. Quintero. Is that who we're looking at?
It's this
Yes,
my
sir.
client's sister-in-law. Yes.
Okay. Court finds the parties agree that that placement is safe and appropriate, meeting the needs of the child. Court will find that at this time that is subject to a request for an expedited home study. So the court will order the expedited home study, and provided it comes back clear, maintain that placement. If something pops up, you guys need to pivot. Obviously, you don't have to come back to court to do that on the short term, but if you do need court intervention, if the placement falls through, then we can set something on the calendar. I have to admonish the parents of the state of Texas, whose parents in CPS cases 12 months to demonstrate you can provide a safe, stable, violence and drug-free home for your child. In the event you cannot do so, your rights to your child are subject to restriction and or termination. Is there anything I've failed to address?
No, Your Honor.
Okay, well, thank you all for your time and your service. We'll be back for a status hearing March the 8th, 2024 at 11 a.m.
Thank you, Your Honor.
Thank you. All parties are excused.